Hi, my name's Cara Zacharias, and today I'm here speaking on behalf of the New South Wales Minister for Health to help you understand how the Voluntary Assisted Dying Act 2022 works here in New South Wales. This legislation came into effect on the 28th of November 2023, representing a significant development in recognising the right to bodily autonomy, providing a safe, legal and compassionate option for eligible individuals to how they wish to approach the end of their lives. In this video, I'll walk you through the eligibility criteria for voluntary assisted dying, or VAD, the request and assessment process, what role medical practitioners play, legal safeguards, and some of the key ethical considerations that the Act raises. To be eligible for voluntary assisted dying in New South Wales, an individual must meet several criteria as per Section 16 of the Act. Firstly, they must be 18 years or over with decision-making capacity. This means that the individual making the decision understands the choice they're making and its consequences. They must be an Australian citizen, a permanent resident, or have lived in Australia continuously for at least 3 years. Additionally, they need to have lived in New South Wales for at least 12 months unless the individual has been granted an exemption. The person must be experiencing suffering that cannot be relieved in a way they find tolerable. This suffering must be caused by a medical condition that is advanced, progressive, and expected to cause death within 6 to 12 months, depending on whether it is neurodegenerative. Finally, the decision must be entirely voluntary, free from pressure or duress. It's important to note that having a disability, dementia, or a mental health impairment alone does not make a person eligible for VAD. Once an individual is found eligible for VAD under the Act, the next step is a carefully structured request and assessment process, which is designed to ensure that the individual's decision is well informed and wholly voluntary. The first stage is for the individual to make a first request to a medical practitioner. This request must be made personally. No one else can make the first request on the individual's behalf. Following this, the person must be assessed by 2 separate medical practitioners, a coordinating practitioner and a consulting practitioner. Both practitioners must independently confirm that the individual meets all the criteria for eligibility under the Act. If the practitioners deem the individual to be eligible for VAD, the person then must make a written declaration confirming their decision. The declaration must be signed and witnessed in front of 2 people. The next step is the final request, which is made to the coordinating practitioner. The individual must wait at least 6 days after the first request before making the final request, unless the person is likely to die or lose capacity sooner. Once all the steps have been met, the coordinating practitioner will do a final review, confirming all legal requirements have been met and they are satisfied the individual is eligible and acting voluntarily. After the final review is complete, the person then makes an administrative decision. This means the individual chooses whether to self-administer the medication or have it administered by a practitioner. If the individual chooses to self-administer, they must also nominate a contact person who agrees to act in this role. Lastly, a voluntary assisted dying substance authority is issued by the New South Wales Voluntary Assisted Dying Board in relation to the person. While medical practitioners have a central role under the Act, participation is entirely voluntary. Registered health practitioners with a conscientious objection to voluntary assisted dying are not required to participate. However, even objecting practitioners must record the first request in medical records and notify the VAD board within the required timeframes. The Act contains safeguards to ensure that VAD is only accessed by eligible people and is most importantly a voluntary process. These safeguards not only include mandatory independent assessments, strict eligibility criteria, and oversight by the VAD board, but a key safeguard is that healthcare workers are not to initiate discussions regarding VAD, nor are they able to suggest VAD to the person. This safeguard protects the individual's autonomy and ensures that the decision to access VAD is entirely voluntary and self-directed. While the Act was designed with strong safeguards and reflects the government's commitment to compassionate end-of-life care and individual autonomy, practical barriers remain. Under federal law, discussing VAD via telehealth is prohibited. which limits access for people in rural and remote areas. This restriction may affect availability of VAD services for patients in rural and remote areas, while also creating uncertainty for healthcare practitioners surrounding the legality of telehealth consultations. Additionally, the requirement to have lived in New South Wales for at least 12 months unless granted an exemption may pose significant challenges for individuals who have recently moved or are in palliative care near a border. While this safeguard was implemented to prevent people from other jurisdictions where assisted dying is not lawful from travelling to Australia to access VAD, it may affect those with genuine connections to the state who do not meet the residency threshold. These issues raise practical and ethical considerations about equitable access to VAD, particularly individuals in rural areas or those affected by strict residency requirements. The Voluntary Assisted Dying Act 2022 New South Wales provides a safe, compassionate and legal framework for eligible individuals to make a voluntary choice at the end of their life. If you or someone you know is seeking more information, we encourage you to speak to your GP or visit the New South Wales Health website for more resources and support. Thank you.